the lawyers forum for 19 minutes. Let me start the matter of truth and declare by saying that the recent judgment handed down by the Honorable Justice of the Court of Appeals in Abuja between His Excellency Abba Yusuf, the duly elected governor of Kabir State, and the need to a reasonable extent miscarriage of justice. This is our honest opinion, even though it might not be too popular.
All right, sorry, we are starting again. Yes.
Me, tell me just making proof come forward because they too bad. They might be covering people. Just bring forward the data. Sorry, we are sorry. Yeah. Yes, better. Thank you. Thank you, sir.
No one contest election.
Okay, good day, everyone. Like I said, my name is Barrister Yusuf private legal practitioner using counsel. This is the Volunteer Lawyers Forum for the 19 United States in support of His Excellency Abba. Let me start as a matter of truth and clarity by saying that the recent judgment has been handed down by the Honorable Justices of the Court of Appeal sitting in Abuja between His Excellency Abba Yusuf, the duly elected governor of Kabir State, and the APC is a reasonable extent a clear miscarriage of justice. This is our whole opinion, even though it might not be the popular opinion. The first stress of this injustice started with the disposition of the trial tribunal, when on the date of the court's judgment, it avoided a full court and open hearing of the judgment, while resorting to the nature of mistrusted bench by rendering their decisions on the internet, online. The people of Kano State then, and the totality of the generality of public in support of truth and justice across Nigeria and indeed the world, we are bewildered by the unfortunate incident. Be that as it may, this recent incident is usurpation of the political will and rights of the common man in Kano State, who voluntarily came out en masse to cast their votes for their choice candidate, His Excellency Governor Engineer Kabir. In the wording of one of the renowned professors, Dr. Kabir, who is a renowned scholar residing in Atlanta, United States, he put it this way, and he said, and I quote, "It is oddly ironic that the judiciary, which should be the bulwark of democracy, has become such a dreadful terror to democracy, that people are now seeking to protect democracy from it. The courts have become the graveyards of electoral mandates. Judges have not only descended to being common procedural judicial roles, but they have also become judicial equals." This is around that laymen will make outright and radical and obvious prevailing comments on of our temple of justice. This can only happen as a result of our sheer possibilities created by our own means. We have opened the doors by our judicial responses to our new constitution. One court delivers judgment, multiple decisions on the same or similar subject matter and the same issues for determination, and all but the same justices in the same time. He went on to say, the same professor, that the major preoccupation now of pro-democracy activists is no longer how to keep military from politics and governance, but how to save democracy from corruption. In other words, in Nigeria, our problem is no longer the fear of military coups, but the cold reality of frighteningly escalating judicial coup. A judicial coup, according to him, he said, refers to a situation where judicial or legal processes are deployed to subvert the choice of the electorate or to unfairly change the power structure of an existing government. Judicial tools therefore fall when the courts are used to achieve political ends that will not be possible through standard political processes. Here, the courts makes ruling and interpretations of law that drastically alter the balance of power, often favoring a particular political group or leader. And this can include invalidating election results, removing elected officials from office, altering the constitution through interpretive tyranny, or other significant legal actions that have profound political implications. Ladies and gentlemen, this is our true and current reality. And without missing words, you are all aware of the plethora of cases and judicial decisions from the beginning of our democratic regimes to date, which reflects the above-quoted facts. In essence, we are our own enemies. The amiable scholar stated in his article that the case of judicial theft of Kano State's governorship election from NFP APC is too well known to warrant restating. The judiciary invoked matters that were extraneous to the actual vote, false technicalities, to decide who to crown as the minister of the elections. It is now so bad that the voting, the votes of the electorate is no longer an important component of our democratic processes, since politicians can now get from the court what they lost at the ballot boxes. That's a dangerous state for any democracy to be, and I share this conviction. Make no mistake, this is not an attack on the honor or personalities of our respective honorable justices who have done their part in rendering their selfless national service. But we should be strict and blunt while speaking on issues that affect the politics of Nigeria. It is not part of our rights to bring their judicial responsibility to disregard or disregard, but it is well within our rights to critique the findings and solutions of the learned trial justices where necessary. As it is widely said, and I quote, justices are not infallible. The judicial system now is being made a caricature of itself and of our own existence as a people. We depend upon the system that is clearly set to bring us an inevitable end. Almost every judgment or decision will be replete with traces of unimaginable conclusions. Truth be told, you are no longer sure of the outcome of court decisions in this country, even if you are a legal practitioner, no matter how knowledgeable you may be. Our reasonings now that, and it's pertinent for us to state here that the Electoral Act needs a holistic reworking in order to address these anomalies of our judicial system and democracy, if we must see it. Re-election matters must be seen to be addressed as no longer matters of litigation after the winner of an election has been declared a winner. And the attempts by courts to conclude upon their findings to declare politicians as winners must also be divested of these powers. At best, orders as reruns in affected areas should be made. The dangers are that if these trends should proceed without checking, then there will no longer be need for open balloting and casting of votes by the general electorate as their mandate. It will eventually be taken over by those who know the rules of the game. And of course, it will no longer be a matter of who won the election and the general voting process. The issues are too numerous to mention. But we all seated here believe in the strong way of a free and fair judicial system. We believe honestly in the powers of true democratic system and are still optimistic in the judicial system. So much so that we admit the fallibility of our justices as human beings. We are hopeful that the apex court, where we are heading now, will do the right thing devoid of any sentiment and paying able and competent attention to the happenings of the just delivered judgments. It is our optimism that the lot of the common man in Kano State will be protected and the yearnings of our people will be respected. We strongly believe that the apex court will do justice by affirming and categorically stating that the duly elected governor of Kano State is His Excellency Abba, whose adequate votes were casted by the populist approval of the people of Kano State. And on this hope, we volunteer as private legal practitioners across 19 member states of this country to participate in solidarity with His Excellency Abba Kabir by the Supreme Court of Nigeria to represent the truth in fight to retain his mandate and that of the people of Kano State. judgment, how the final closing decisions of the leading judge in the case, specifically at page 6 to 7, where 5 paragraphs were contradictory, one after another. This cannot be an oversight. If it is a mistake, as they have stated, it is indeed an unforgivable mistake. Permit me to close on this note by quoting one last statement of the learned scholar who said, and I quote, "In all functional democracies, it is the vote, not the courts, who elect and remove people from positions of political power. If the courts find sufficient irregularities in the conduct of elections, they can order for wrong, but they should never be invested with the power to declare winners and losers." And indeed, we all know whose responsibility that is. It is of the INEC, and she has discharged her responsibility in our case. Officially issuing certificate of return to the undisputed sitting governor of Kabir State, His Excellency Abba. Thank you.
Thank you very much for that statement. It's now time for questions. Questions will be asked by members of the press to yourself and other representatives of the forum who can speak on the issues. To the floor. Any question, please?
All right. Yeah. Very good morning. Okay. Very good afternoon. I'm glad to hear my name. All right. For leadership. Yeah. Your test is actually explicit. However, I want to ask as a layman because there seems to be divergent views even among senior learned colleagues, you know, against and for. So what exactly, at the risk of taking sides, what do you call clerical error in the judgment? Because a number of the senior lawyers called what happened in the CTC, the content of the CTC where you are quoted at page 67 as a clerical error. Is that telling? I've asked this as lay person, hoping that you will clarify. And to what extent do you think that your position as it stands now is supportive of the excellency? So, because it or prior to the Supreme Court judgment, we have anything else?
That's one. Number 2.
All right. Second question from Channels Television.
Good afternoon, police. Like you're always using court as the court cases. I expected that the tribunal has spoken, the appeal court. Now looking at the court of the first trial, which is the tribunal, and the judgment and the last of the appeal court, what do you make out of it, the two judgments? And considering that this matter is right now before the appeal court, it's not a kind of prejudice for you as young lawyers who perhaps tomorrow will be the learned judges up there to comment on this particular issue that is still pending before the appeal court.
Another question from TVC.
Good afternoon. You seem to be calling for electoral reform and an overhaul of the Electoral Act. How important do you think this is, and how timely should this be done?
Last question from myself. Mr. Gabriel from Arise News. My question is this. What is your assessment on the independence of the judiciary as it stands now? Is there any assumption, or are you guys assuming that the executive is somewhat influencing decisions coming out of the judiciary as it stands now? We can start with you. Maybe you guys can just swap places. Yeah. Yes. Okay, sir. Just maintain position. No, you can swap.
If you won't use it, it will contradict.
Sorry, your name again.
Once again, I welcome all members of the press and lawyers that gather here from the United States and all the country. Let me start from the last question asked about the assessment of independent of judiciary so far. Don't forget, we have a doubt that our judiciary is not independent. I will be contradicting the provisions of the Constitutional Republic of Nigeria, as it's stated that Nigerian judiciary is independent organ of government. However, the public always have this kind of a misconception of independent of judiciary. Now, when a common man started saying something going around in the public about a problem he has foreseen in one arm of government, all of us, even we lawyers, we start thinking that something fishy is happening. Let's assume what happened just recently as we gather here in respect of the judgment delivered by the Court of Appeal, in respect of the governorship election of Kano State. Many people, not only lawyers, are now doubting the true independence of the judiciary. Let's assume Kayode is sure of, let's remember, in the case of Ojubu as governor of Lagos State, I've marshaled out what independence of the judiciary should be. A judiciary should be someone that will deliver judgment to people without any fear or favor to a particular person, not considering his class, being the top politician, the common man. And that's why all of us and many scholars have regarded judges as variants of the God of the arts. And God is independent of his own. And if God has taken you to be a kind of a judge to adjudicate between issues, between artists, you should always know you are doing that as what? As a vicegerent of Almighty Allah subhanahu wa ta'ala. And you should be able to do justice so that, and justice is what public will assume, that even you, a reasonable man, will see that justice has been done. And that is why it's publicly saying, not only be done, but must have seen. Discovery that we independent of judiciary saying that they are on trial, and our prayers are always on the bench. That their independence will always be ensured and reassured to allow our internal mechanism of democracy to flourish. Thank you. Coming to the question of what is clerical error. Clerical error, I don't know the definition one used to give. The court in collaborative cases have given the definition of what a clerical error is. But me too, the question further proceeds, what will then amount to a clerical error? Take into consideration when the judgment was delivered and almost 5 paragraphs are contradicting each other. Then what is, me too, I'm asking, what will then amount to a clerical error? Because the clerical error has been well defined and how it can be corrected. But in the issue of the Abba that is at hand now, His Excellency, that is your counsel, I question myself, what then amount? Can entire paragraph 1, 2, 4, 5 amount a clerical error? And then it was a CTC, a certified true copy. The Court of Appeal also explicitly interpreted what a CTC is in the case of City Minister versus Viviana. It's just 2022 report. It said the CTC copy is a reproduction of exact original documents. Then my question is, where is that original? Is it the original that was so beclouded before the planetary era? We are not doubting about for our noble boss. What we always say as part reasons. But we also quest further what then amounts to the planetary era in kind of distribution where paragraphs will be contradicting each other. And that's you two members of the press to find the meaning from the dictionary. Commenting on the pending case with respect to these as a lawyers with no ethics, and that's why we're trying to put our practice within the core ethics and value of legal profession. Nobody is commenting what Supreme Court will do. The Court of Appeal is not from the official. It's like the judgments are now false. And what we are commenting is basically on the decisions and the findings of the Court of Appeal. Not what is wrong. It does not extend to Supreme Court. It is not that the appeal is pending before the Supreme Court, and we can't comment. But the decision of the Court of Appeal, which has already been handed down, and it's now, even the CTC has circulated to everyone, members of the press, before only lawyers have the CTC. But in this Abba case, I think everybody, even a layman, have the CTC copy of that judgment. That is why everybody will comment, because it's a decision of the Court of Appeal which has been handed down already. So we are not being prejudicial to the Supreme Court with all respects. The question of the CTC challenge on the electoral reform. Election about electoral reform. In every time, it is the much yearnings that took the members of the National Assembly to, again, take it as a neutral on them to amend the Electoral Act 2010. And what we are saying always, our electioneering processes are still developing. And let me tell you, it is developing not only because of the attitudes of the politicians, but even because of the attitudes of the lawyers that approach the courts seeking interpretation of the sections or provisions of any electoral acts. When we had the Electoral Act 2022, we are all saying that now we have a perfect electoral guidelines, laws. In fact, one of my senior colleagues was telling me, Mr. Shepherd, it's like this time around we may not be having much litigation on electioneering processes. I said, sir, I doubt that. Being even one of the youngest junior, I think this year it will be most populous. The court will be so full with electoral litigation, reading the provisions of the Electoral Act. And that's what's happening. Even from the parties, primarily, internal democracy of the party, we have been trying to be trumpeted by the political actors, and the lawyers were helping them by giving them some interpretation and approach the law. I think even the country will agree that they have, let me say that they have had a much number of electoral litigation in the court more than any other Abba. That's still, we see clamor for the electoral reform, sort of this kind of nature, because even the judgment of the Council was based mostly on Section 137, which to us technically, that was not the interpretation because in the case of a delegate versus a neutral act, Supreme Court can do justice in that section, what is the instruction in us, how it's supposed to be interpreted. But the noble one who gave the judgment at the prior tribunal said that no, they strictly apply the provision of Section 137. So again, by removing the votes of many populace of Kano, that is what will cause a problem when a common man have come out, voted, and you are now sitting in one tribunal with all respect that you are removing their votes. It will have a kind of a repercussion. And that is what we have been witnessing in Kano since last 2 weeks. Every day you find a peaceful protest. Every time, I think my friend here always report wherever there is a peaceful protest going on in Kano, there will be repercussions. Because they know they have voted His Excellency Engineer Abba Kabir Yusuf, and let their votes count and let their votes be. Thank you very much.
Thank you very much. With that, we have come to the end of the... archaeology places. All right, thank you very much.